Young Thug's attorney, Brian Steele, has filed a brief before the Georgia Supreme Court in his contempt case. If you remember, Judge Glanville held Brian Steele in contempt when he refused to tell Glanville how he obtained the information about the ex parte meeting between Glanville, the prosecutors, and witness Woody Copeland. So this case has gone to the Georgia Supreme Court. At this point, Steele has filed a brief before the state's highest court. Now, Glanville sentenced Steele to 20 days in jail, which he was to serve from that point forward every weekend, so 2 days per weekend for 10 weekends. And Steele, in a gangster move, asked if he could serve with his client, Young Thug, so that they could get some work done. And Glanville said yes. The Supreme Court suspended that sentence. They put a hold on it, so Steele did not have to serve his sentence. And now he's filing a brief before the Supreme Court in this case. I'm going to read from the argumentation, and then I'm going to read the conclusion. So let's start off with the argument number one. There was insufficient evidence to support Steele's contempt conviction beyond a reasonable doubt. A. The use of contempt powers is only appropriate where the conduct in question threatens the administration of justice. Generally, contempt of court refers to an individual's disregard for or disobedience of the order or command of the court, which includes the interruption of court proceedings. Georgia law grants state judges broad authority to preserve order in their courtrooms, and the contempt power exists so judges may execute and enforce the public duty, although that power is limited by both the state constitution and legislation passed by the General Assembly. While the power of courts to punish misconduct and ensure compliance with its orders and its directives is broad, it is not absolute. Contempt is a drastic remedy which ought not to deprive one of his liberty unless it rests upon a firm and proper basis. That's from Martin v. Waters' case. When addressing contempt matters, any doubts must be resolved in favor of vigorous advocacy. To that end, the court must not violate the constitutional and statutory rights of the alleged contemptor, nor may it conduct the contempt proceedings in a way that violates fundamental notions of fairness and due process. Georgia courts recognize two types of contempt, civil and criminal. The distinction between criminal and civil contempt is that criminal contempt imposes unconditional punishment for prior acts of contumacy, whereas civil contempt imposes conditional punishment as a means of coercing future compliance with a prior court order. So that was A. B. Steele's conduct did not interfere or threaten to interfere with the administration of justice. Like all crimes, contempt has an act requirement called the actus reus and a mental component, the mens rea. To satisfy the actus reus, there must be sufficient proof that the act in question constituted an imminent threat to the administration of justice. The arguments of a lawyer in presenting his client's case strenuously and persistently cannot amount to contempt of court so long as the lawyer does not in some way create an obstruction which blocks the judge in performance of his judicial duty. Here, Steele merely attempted to make a record of proceedings that he believed violated his client's rights, but did nothing to interfere with the administration of justice. Nothing about Steele's behavior prevented the trial from proceeding or otherwise interfered with the administration of justice. In fact, the court explicitly acknowledged that the exchange with Steele would have no impact on the trial schedule, stating that it was going to move forward with the trial with Steele's co-counsel, Keith Adams, representing Williams while Steele was in custody. C. Steele's conduct did not exceed the boundaries of permissible advocacy. To sustain the contempt conviction, this court must also find that the evidence established beyond a reasonable doubt that Steele knew or should have known that his conduct was outside the bounds of permissible advocacy. As noted above, this element is the mens rea for criminal contempt, as an attorney can only be found guilty if he knows or reasonably should be aware, in the view of all the circumstances, especially in the heat of controversy, that he is exceeding the outermost limits of his proper role and hindering rather than facilitating the search for truth. The court has identified a non-exhaustive list of factors that are probative of whether the attorney knew or should have known that his conduct exceeded the boundaries of acceptable advocacy. D. Steele's alleged contempt was not willful. Finally, Steele's conviction cannot stand without evidence that he acted willfully. Here, the record fails to establish willfulness and is, in fact, replete with support to the contrary. To prove willfulness, there must be proof beyond a reasonable doubt that the alleged contemptor had the power and ability to comply with the court's order and chose not to do so. Georgia rules of professional conduct set out the minimum ethical standards that attorneys practicing in Georgia must follow. Georgia Rule of Professional Responsibility 1.6 requires an attorney to, quote, maintain in confidence any information the attorney learns through his professional relationship with his client, quote, whatever the source. As discussed in more detail below, Steele could not comply with the court's order without violating his constitutional and statutory duties to his client and his professional obligations under the ethical rules. Therefore, his refusal to answer could not be willful. E. The trial court did not make the requisite findings to hold Steele in contempt. Critically, the contempt order here is wholly deficient in that it fails to set forth with specificity several things, including, quote, an explanation of the deleterious impact of the court's operations or its integrity of the conduct in question, and the basis for finding that there was no justification for the attorney's behavior. The court's final order maintains none of the requisite findings, as it only cites that Steele, quote, repeatedly refused to follow the court's order to tell the court how he came into that information about the ex parte conference. Clearly, there is no evidence in this record to conclude that Steele's advocacy on behalf of Williams or his refusal to identify the source of his information interfered with the court's ability to administer justice and preside over the trial. So that was all one. Now two. The trial court's directive that Steele disclose privileged information was unlawful and created a conflict of interest between his and his client's interests. A. The trial court could not validly order Steele to violate attorney-client privilege. The trial court was wrong to discount Steele's position that the attorney-client privilege prevented him from revealing the source of his information. The attorney-client privilege, the oldest privilege for protecting confidential information, is founded on the need for attorneys to have full and complete information without fear of disclosure to represent their clients. B. Ordering Steele to reveal confidential information, the trial court improperly created a conflict between Steele's interests and those of his client. Steele's client has a constitutional right to the counsel of his choice who is free of conflict. An attorney has a conflict where he faces a choice between protecting his own interests and protecting those of his client. Here, the trial court attempted to create a conflict between Steele's personal interests and those of his client. Steele has an obvious interest in defending himself in a criminal matter and from accusations of contempt and in avoiding jail. But he has an equally compelling interest in zealously representing his client's interests and honoring his ethical obligation under the Georgia rules of professional conduct. 3. The trial court erred in failing to afford Steele the due process to which he is entitled. A. The trial court erred by failing to recuse itself and refer the matter to a different judge. As described above, strict due process requirements apply before a court can hold someone in contempt because of the heightened potential for abuse posed by the contempt power. Any trial court considering criminal contempt sanctions against an individual must act dispassionately without personal reactions or injecting the court into the case. However, where a judge becomes personally embroiled in the controversy that is the subject of the contempt, or where the announcement of punishment is delayed, the judge must immediately recuse from the matter and refer the contempt proceeding to be heard by a different judge. B. The trial court erred by using the summary contempt procedure when there was no immediate threat to the court's ability to administer justice. Georgia courts are statutorily authorized to inflict summary punishment for contempt of court for various different types of misconduct, a procedure that provides for fewer due process protections. However, summary punishment always and rightly is regarded with disfavor. Summary disposition is tolerated only if there is an immediate threat to the court's ability to administer justice. C. The trial court denied Steele his due process rights of notice and opportunity to be heard and representation by counsel. As described above, the contempt proceedings evolved throughout the day as the court at various points held Steele in sua sponte criminal contempt, informed him that he could purge the contempt by providing the information demanded by the court, and then reversed course again when it ultimately held him in direct criminal contempt and sentenced him to 20 days in jail. 1. Whether civil or criminal, the trial court denied Steele the due process to which he was entitled when it initially held him in contempt. 2. Even if the court properly used the summary criminal adjudication procedures, it still deprived Steele of the meaningful opportunity to be heard. And 3, when the trial court imposed the final criminal contempt sentence, it failed to afford Steele the due process to which he was entitled. Conclusion. As described above, the trial court abused its contempt power by holding Steele in contempt when Steele was fulfilling his duty to zealously advocate on behalf of his client, and it did so without affording Steele any of the due process protections required by law and without recusing itself as mandated. Because there is no basis on which to conclude that Steele was engaged in contemptuous conduct and the record and contempt order are deficient, a reversal of the conviction is warranted without reprimand. So there we have it, y'all. This is a summarized version, kind of a skipping around version, just trying to get all of the most pertinent information from Steele's brief before the Georgia Supreme Court. What do you think, y'all? Do you think that he will win this case? Doesn't it seem like Glanville should just remove his contempt order and just be done with this? Anyway, comment, like, subscribe. Let me know what y'all think about this, and we'll be back for the next one.
Yeah, come on now. Don't come in the court. We'll come and get you that.
Thank you. Go ahead. The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information and belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to...
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information...
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have his... I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why?
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I tell you
what, I'm going to give you 5 minutes. If you don't tell me if you don't tell me who it is, I'm going to put you in, I'm going to put you in contempt, because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing